Welcome back to Prime Time. ਜਿੱਦਾਂ ਮੈਂ ਦੱਸਿਆ ਸੀਗਾ ਅੱਜ ਸਾਡੇ ਨਾਲ Kate Saldanha, Wills Estates and Real Estate Lawyer ਆ Proust & Crouch ਨਾਲ ਉਹ ਸਾਡੇ ਨਾਲ ਅੱਜ Wills ਬਾਰੇ discussion share ਕਰਦੀ ਹੈ. Kate, welcome back again.
Thanks, Paul.
When we broke before the commercials, we were talking about where wills are placed. And you were explaining that we give clients a number of documents, and then the original will is usually kept at a fire safe at Proust & Crouch?
Yep, that's right. So one original copy of each of the documents that a client's coming in to sign, so that's usually a will and a power of attorney for personal care and a power of attorney for property.
Okay.
We keep one original of each of those documents in our vault for safekeeping. So the good news is we're giving clients a package to take home, but even if something happens to that package, we have them all on site as well.
Okay.
Now the package that you take home, you want to keep it somewhere that's in your own control. So you want to keep it at home, but also somewhere safe and somewhere that whoever you've named that may need to use these documents can find them. So the number one question that I get that makes sense but is actually a really bad idea once you think about it is putting these papers in a safety deposit box at your bank.
Right.
So a safety deposit box is very safe and it's wonderful, but there's a couple of problems. Firstly, what if something happens on the Friday of the long weekend and no one can get in there until Monday or Tuesday or whatever the case may be? But the bigger problem is if I need to get into the safety deposit box to get that document, the document that gives me authority to get into your safety deposit box is sitting locked up in the box.
The power of attorney itself.
Exactly. So how do I show that I have authority to get in there for you because it's already locked up in the box? I can't get to it.
Right. You indicated that Proust & Crouch keeps copies of the original will at the office in a far safe, secure location.
Yes.
Do they do that as a courtesy?
It is a courtesy, and it's to give clients that peace of mind that nothing is happening to these documents, that we have a secure copy they don't need to worry about. And when the time comes that if they pass away or someone needs to use that power of attorney document on their behalf, we can release it to them when it's appropriate.
Right.
So if a person has passed away, for example, we're not giving out the original will unless we have a death certificate and ID that tells us that it's the executor who's named in the will that's here to pick it up.
Right, so there's no monthly or annual fee with respect to that. That's a service that Proust & Crouch provides to its clients to keep that safe.
It is, and I will say it's an option. You don't have to keep your documents in our vault if you don't want to, but for the convenience and peace of mind, and since it is no extra cost, a lot of clients do choose to do that.
Right. You also indicated that you would yourself or one of the wills lawyers at the firm would give a copy to an individual. They can put that somewhere safe. It's not recommended that they put it in the safety deposit box, but are they entitled to make several copies of that? Maybe keep one in the safety deposit box and keep one at home as well?
So the copy of the will that we give to clients, it's clearly marked copy. There's no signature anywhere on it. So if you wanted to put that somewhere secure or make multiple copies, that's fine, because if you pass away, it's not the legally enforceable or the legally valid copy.
It has to be the signed copy?
It's that signed copy that's in our vaults.
To be a valid will?
Yes.
Are there witnesses needed to witness the signature? What's required?
So there's different ways that this can be done.
Okay.
The simplest form of a will, in its kind of most basic element, is you can take pen to paper and you can handwrite in your own handwriting a will for yourself and sign it. It's more informal. Going back to law school, one of my favorite cases that we learned about was someone who'd written a beautiful poem as their will.
Right.
And it was fantastic and everybody loved it. It was very arty. But no one knew what it meant. No one knew who was supposed to get anything or who was supposed to be in charge. So doing a handwritten will is convenient because you can do it yourself anytime, anywhere. But whether it's going to actually be very helpful when you pass away or not is kind of a different story. It
should be clear and concise.
Exactly. And the advantage of working with a lawyer is that you're working with someone who does this for a living. We know what the court expects of us, what the law requires of us, and it's our day-to-day job to make sure that all of those boxes are ticked, if you will. If you're doing this without that kind of training, it makes it much easier that you might make a mistake.
Let's just take a scenario, a fact pattern. You have somebody that doesn't have a will. They fall gravely ill. They're hospitalized, and they don't have an opportunity of meeting with a lawyer. Sometimes we have these diseases that it's hard to recover from. Sometimes doctors can almost predict how much time one has left.
Yes.
When somebody's in hospital, in that situation, is there any ability for them to give instructions to a lawyer, or for a lawyer to then still do a will for that person?
Yeah, so it can be possible. It really depends on the individual situation. So in order to make a will, in addition to being 18, as we've talked about, you need to have mental capacity. So you need to have kind of the mental wherewithal to understand what you're doing and the implications of it.
Let's say there's no issues with respect to mental faculties.
Yes.
And it's another major illness one has.
Yes.
They're just not able to leave the hospital.
Yep.
They can talk to you, they know what they have, they know about all of their family members. What I'm basically asking is do you or people from the firm make hospital visits?
So yes, it's possible, and yes, we do.
Okay.
We never want to encourage clients to be in that position,
right.
because I can tell you I've made several of these visits to the hospital for clients, and it's very stressful for the client, because they're already experiencing this medical event, they're in the hospital, they're concerned that the end is near and they might be passing away, and to add on to that, a lawyer is coming in and asking you questions and making these documents, and you have to sign them. It's not a very pleasant experience. If that's kind of your only choice because you haven't made those arrangements in advance, great, it's fantastic to have that as an option, but my goal is to make sure that my clients are getting these things arranged when
beforehand.
You're healthy and you're not stressed, and you're in a good position to be making these decisions without any added pressures.
Right, and again, that's why you've indicated it's best to do it as soon as you become an adult.
Exactly, and I mean, there's no rule that you have to make a certain number of wills in your lifetime or every specific number of years, but the sooner you do it, you can make changes as often as you want to. So as you get married, as you have kids, whatever the situation may be, you can tweak the documents that you already have.
So let's just talk about that very briefly. You've said that you can make changes, okay? Again, somebody comes to you, they're 18 years old, they're single, they're employed, a number of years later they find someone, they get married, they have children, years later they have grandchildren. Do they have to then make a whole new will? So
it depends. So for some people, if it's not been too long since they made their last will, maybe there's not a lot that they need to change. So we can make something called a codicil. And a codicil is basically a one-page amendment, or like a slip sheet, going back to typewriter speak, where you're changing just one thing, maybe just one paragraph. You're changing your executor's name, for example, is a pretty common one, without having to redo the whole will. Now, the thing that I also say to clients is that over time, not only are your needs going to change, but the law might change a little bit too.
Right.
So let's say you have a will that's 30 years old, and the only thing you think you want to update is the executor. That's fine, but there might be some other reasons to make your will more efficient, changes in tax laws, that sort of thing, that it might be advantageous to do a new will anyway.
I just wanted to go back to a point that we briefly discussed before about the simplest form, the handwritten will. Can it be typed and then signed at the bottom?
So you may have seen there's will kits available.
Right.
There's some online forms that you can use as well. For the powers of attorney, the province of Ontario actually makes forms that you can fill out for the powers of attorney. And I have a bit of a love-hate relationship with these forms, because I love them in that they're well done and they're a valid thing to do, but I hate them because you have to fill them out exactly correctly, even though you don't have legal training. And if you make a mistake on it, there's no saving it. If it's not done properly or filled out properly, or the signatures aren't correct, or someone who's not allowed to be your witness has signed, you might as well take it, crumple it in a ball, and throw it over your shoulder, because it's not going to help you.
It's not going to give any effect.
No, and in fact, I actually met with some clients just a couple of weeks ago who we were doing that consultation like we talked about earlier, and they were very proud to show me that they had made the powers of attorney
themselves
on those government forms. And so I said, okay, great, like let's just take a look and see what you've done to make sure that it matches up with what you'd like to do. And unfortunately, the only thing that they had done was put their names on it and had it signed and witnessed at the bottom. They didn't actually name an attorney to help them be in charge if they couldn't on their behalf. They didn't put in any sort of other information or guidance. It was completely blank. And
right.
You know, it's unfortunate because they had the feeling of comforted that they have these documents, but they wouldn't have helped if they actually were needed. And the challenge that we have with both the wills and the powers of attorney is usually by the time a professional is actually looking at these documents, it's because someone wants to use them. So someone has lost their capacity and their attorney is stepping in, or someone has passed away and their executor is stepping in. And at that point, there's no recourse to fix these documents.
Right.
If they're not done properly, it's too late. We're stuck with dealing with whatever legislation is in place to help us for people who don't have those documents.
Right. ਜਿੱਦਾਂ ਕੇਟ ਸਲਡਾਨਾ ਨੇ ਆਪਾਂ ਨੂੰ ਦੱਸਿਆ ਵਾ, it's always preferable, ਤਾਂ best option ਤਾਂ ਇਹ ਹੁੰਦੀ ਹੈ legal advice ਲੈ ਕੇ will ਬਣਾਉਣੀ. ਬਟ ਜੇ ਤੁਸੀਂ ਨਹੀਂ ਲੀਗਲ ਐਡਵਾਈਸ ਲਈ, ਤੁਸੀਂ ਜਿੱਦਾਂ ਇਹਨੇ ਦੱਸਿਆ, ਤੁਸੀਂ ਪੈਨ ਐਂਡ ਪੇਪਰ ਲੈ ਕੇ ਤੁਸੀਂ ਆਪਦੇ ਲਾਸਟ ਵਿਸ਼ਸ ਲਿਖ ਸਕਦੇ ਆ. ਤੁਸੀਂ ਹੈਂਡ ਰਿਟਨ ਵਿਲ ਬਣਾ ਸਕਦੇ ਆ. ਉਹਦੇ ਵਿੱਚ ਤੁਸੀਂ ਦੱਸ ਸਕਦੇ ਆ ਜਿਹੜੇ ਤੁਹਾਡੇ ਐਸੈਟਸ ਆ, ਜਿਹੜੇ ਤੁਹਾਡੇ ਜਵਾਕ ਆ, ਉਹਨਾਂ ਨੂੰ ਕੌਣ ਲੁੱਕ ਆਫਟਰ ਕਰੇ ਜਦੋਂ ਤੁਹਾਡੀ ਡੈਥ ਹੁੰਦੀ ਆ, ਤੁਸੀਂ ਕਿੱਦਾਂ ਦਾ ਸਰਵਿਸ ਲੈਣਾ ਚਾਹੁੰਦੇ ਆ. ਇਹ ਚੀਜ਼ਾਂ ਤੁਸੀਂ ਆਪ ਵੀ ਕਰ ਸਕਦੇ ਆ. ਬਟ ਮੈਨੂੰ ਯਾਦ ਆ ਲਾਸਟ ਵੀਕ ਅਸੀਂ ਤਾਂ ਮਸ਼ੀਕਾ ਭਾਜੀ ਉਹਨਾਂ ਨੇ ਗੱਲ ਕੀਤੀ ਸੀਗੀ, ਕੋਈ ਨਹੀਂ ਚਾਹੁੰਦਾ ਡਾਕਟਰ ਕੋਲ ਜਾਣ ਨੂੰ, ਤਾਂ ਕੋਈ ਨਹੀਂ ਚਾਹੁੰਦਾ ਲੋਅਰ ਕੋਲ ਜਾਣ ਨੂੰ. ਬਟ ਜਿੱਦਾਂ ਆਪਣੀ ਹੈਲਥ ਵਾਸਤੇ ਆਪਾਂ ਡਾਕਟਰਾਂ ਨੂੰ ਮਿਲਦੇ ਹਾਂ, ਆਪਣੇ ਜਿਹੜੇ ਰਾਈਟਸ ਆ ਤਾਂ ਮੇਕ ਸ਼ੋਰ ਕਰਨ ਨੂੰ, ਜਿਹੜੇ ਆਪਣਾ ਲੀਗਲ ਓਬਲੀਗੇਸ਼ਨਸ ਵੀ ਆ, ਆਪਾਂ ਨੂੰ ਕਦੀ ਕਦੀ ਲੋਅਰਾਂ ਦੀ ਜ਼ਰੂਰਤ ਪੈਂਦੀ ਆ. ਤਾਂ ਆਪਾਂ ਤਾਂ ਇਹਨਾਂ ਐਕਸਪੀਰੀਅੰਸਡ ਪ੍ਰੋਫੈਸ਼ਨਲਸ ਕੋਲ ਜਾਂਦੇ ਹਾਂ, ਬਿਕਾਜ਼ ਆਪਾਂ ਮੇਕ ਸ਼ੋਰ ਕਰਨਾ ਚਾਹੁੰਦੇ ਹਾਂ ਜਿਹੜੇ ਆਪਣੇ ਰਾਈਟਸ ਐਂਡ ਓਬਲੀਗੇਸ਼ਨਸ ਆ ਉਹ ਪ੍ਰੋਫੈਸ਼ਨਲੀ ਲੁੱਕਡ ਆਫਟਰ ਆ. Kate, now with respect to wills, how many wills can a person have?
So you can actually have more than one. So most people don't even know that, because for the average person we do have only one will.
Right.
But for some people, especially business owners, it might make sense to actually have 2 or more wills per person.
Why?
So when a person passes away, if
Yes.
we have to go through a court process, which most people call probate.
Okay.
So you know, if you pass away and we need the court to verify that your will has been, you know, kind of properly executed and prepared, and they're satisfied that your executor can go and do things on behalf of your estate, that kind of whole process is what we usually call probate.
Okay.
As part of that process, we have to pay a fee to the court.
Right.
Of course, you already touched on earlier, there's 2 certainties in life, death and taxes.
Right.
This kind of builds in both. So if you're making that application, you're paying a fee to the court, and that fee is based on the value of your assets. So everything that you own as part of your estate. It's about 1.5% of whatever the value of those items are. So why am I telling you all this? Because if we can take away some assets from being included as part of what we're submitting to the court for probate, we're going to save that court fee on it.
And you're going to obviously save on the taxes.
Well, right. The court fee is exactly that tax, that 1.5%. So
how is that done?
Yeah, so what we do is we gather up all of the assets that we know we need to get that probate certificate from the court in order to transfer. So that's usually things like our house, bank accounts, investments if they don't have a beneficiary named on them. Things like that we put all together in one will.
Okay.
Everything that we know we can transfer without needing to show that court certificate, so that could be things like a vehicle or corporate shares are a big one. personal items, so furniture and that sort of thing, jewelry, items that you have at home, we don't need that court certificate in order to transfer the ownership. So we split those items out, and then when a person passes away and we need probate from the court, we're only submitting the value of the items in that first will. So everything that we can tuck into that second will, especially small business shares or any sort of private business shares and those personal items, we're saving that 1.5% court fee.
Because they're not included in the total value of the estate, it becomes a lot less.
Exactly. We're getting that court certificate only for the items that are included in the will that we're submitting to the court.
Is that preferable for business owners or for individuals as well?
So the main place that we see this being popular is for business owners. Okay. And the reason being, to set up this structure is more expensive than just setting up one will because it's more complicated. So we want to make sure that whatever amount we're going to save in the court fees is going to exceed whatever it's going to cost to set it up.
Yeah, to see if it's beneficial.
Exactly. So we don't want to pay more to set up a structure than you're going to save with the court. That doesn't make sense. So because that needs to be, you know, a relatively high amount, since our court fee is 1.5%, typically where we see this is with business owners because those business shares can have a really big value.
Again, I get questions asked of me if I'm out at an event or, you know, the water cooler questions. Individuals have asked me before if they have life insurance proceeds. Let's just say they have a $250,000 or a $500,000 policy, and the beneficiaries of that policy are the wife and the children. Is that taxed?
So anything that we can name a beneficiary on, so that includes life insurance, like you said, but it could also be things like your RSPs or your registered investments. Yeah. Those get treated differently. They don't get treated as part of the estate. Oh, so your estate is basically everything you own when you pass away that is going to be transferred to someone else under your will. So anything that we can name a beneficiary, we keep it out of the estate, out of the realm of the will. And by doing that, it's going to be more tax efficient because it's not part of the estate, so we're not paying the same kind of tax on it. And we're going to make sure that for beneficiaries, they're getting that money directly from whatever institution has issued that life insurance policy or that we have that investment plan through. So it can usually get paid to your spouse or your children or whoever you've named as the beneficiary. It can go to them much faster than if we have to wait and go through the whole court process
of probate,
and probate and then start distributing money. It takes quite a while longer. And just kind of for reference in terms of how much longer we're talking about, from the time that we submit that probate application to the court, so we have all the information, we've gathered everything, which in itself takes some time, but we submit it to the court, you know, here in Peel, say today, you're looking at a minimum of 3 to 4 months before the court's getting us that certificate back. Absolute minimum. It could run much longer than that. So imagine if you're dealing with something like life insurance, if the company that issues the life insurance can just pay it out to our beneficiary
on a death certificate, they get it
on a death certificate, maybe a couple of forms, it's going to get paid out pretty quickly, versus if we kind of can't even get started on that process until we've waited several months for the court to give us our probate certificate. That's a huge time difference. And especially in the context of life insurance, for example, someone's passed away, the beneficiaries may need that money pretty quickly to continue to pay bills or for a funeral. It's a pretty critical time, and having that money quickly can be a huge advantage.
Now, with respect to wills, obviously there's different wills for people that are single and people that are married. Can you tell us what differences there are? So, for example, someone, again, who comes in at 18, they want to make their first will, they're single. They have very few assets, they got a few $1,000s in their savings, and they just have their parents. It'd be quite simple to do a will like that, I guess.
Yeah, it ultimately, for any will, it depends on what a person wants.
Right.
So I think the number one thing about making a will is you're keeping control. You're having control over who is in charge of things for you, who's going to get things from the estate, at what age, you know, if they have to meet certain milestones like we were talking about earlier. So, you know, it's that control that's so critical, and the things that you may want to do and the people you may want to include at 18 as a single person
Right.
without children is very different than the kinds of people that, you know, who have a spouse and children maybe are considering at a later age.
Let me rephrase that maybe. How does marital status, one's marital status, play a role with respect to wills?
So we mentioned earlier that if you get married, that can automatically revoke your will if
Okay.
you haven't put some special language in there. The flip side is if you're divorced or you're divorcing, it's not quite the same.
Okay.
So for a couple who is legally married but they've separated, that doesn't make any sort of automatic change in your will.
Okay.
So if you've separated from your spouse and you're in the process maybe of getting a divorce, you absolutely need to update your will, because it's not going to automatically change in any sort of way. If you've set up your will to leave everything to your spouse and you pass away while you're separated, that's what's going to happen. So if you update that will, you can change it. Now, there's some other legal implications to what would happen if you pass away while you're separated and you haven't left anything to your spouse, but you're not starting from that automatic place where everything is going to that person.
Let me just ask you about that. Let's just say you have a spouse and children, and for some reason you decide not to name your spouse as a beneficiary, somebody who's going to get something or a benefit from the will.
Yes.
Let's say you decide to leave everything to your 4 children. Is that valid? Can you leave out your spouse?
You can.
You can?
You can.
Okay.
Yeah, so the caveat to that is whether you're going to be successful or not is a little bit different.
Okay.
So for your spouse, if you're a legally married spouse,
Yeah.
and I just want to emphasize legally married because common law partners, so
Yeah.
people, even if you've been together for 25 years in a common law partnership, you're not given the same rights at law as a legally married spouse.
Okay.
And unfortunately, I've had this situation with a few widows where they've been with a partner for 25, 30 years. That partner never made a will before they passed away, and they don't have any automatic entitlement to their late partner's estate at all. Nothing whatsoever. Whereas with a legally married spouse,
Yeah.
even if you've made a will that cuts out your legally married spouse, they have an election that they can make to say, okay, I'm not happy with what my spouse has left for me under the will, and it could be that your spouse leaves you nothing or just less than what you want. If you're just not happy with it, you can elect to make a division that's kind of the same as what it would be as if you and your spouse were divorcing. So as you may know, a lot of, in a divorce, there's kind of a determining of how the assets are going to be split between the couple. And if you pass away and your spouse is not happy with what you've left them under the will, they can essentially have that same kind of process happen even though you've passed. So they might still be able to get some money from your estate, and especially if they were dependent on you. So if perhaps your spouse isn't working and they don't have the ability to support themselves, if they're not receiving anything from you or your estate, that's something the court's going to look at to make sure that they're taken care of.
So basically you really can't leave your spouse out of a will.
Well, it's a choice for the spouse, right? So if the spouse, in the scenario you described where everything is going direct to the kids,
Right.
maybe the spouse is independently wealthy and they're happy for everything to go to the kids. If they don't challenge what's in the will or say, no, I want to make that special election under the family law rights, they don't have to. It could go that way. It's a matter of, you know, the specific circumstances and what everybody wants to do. It's not terribly common that someone would cut their spouse out of a will and the spouse would be happy not to protest it,
Right.
but it's possible.
Kate, we're almost coming up to the conclusion of the show. One last question. Scenario, a husband, wife, they're together. they both have a will. They both name each other as the primary beneficiary.
Yes.
And tragically, they both are deceased at the same time. They both pass away in, say, a car accident or some other natural disaster. What happens then?
So again, if you've made a will, you're going to have those contingencies built right in. So a big part of my job is saying, Paul, here's a bunch of horrible things that could happen in your life.
Okay.
How are we going to deal with it? Right? So, you know, you don't want to imagine a scenario like that where you and your spouse, maybe even you, your spouse, and your kids are all in a car crash together, something like that. But it happens. And so with a will, you can build in some backups about who's going to receive the money in that situation. The problem is, if you don't make that will, whatever rules that the government has put in place in terms of who they think you want to leave your money to is going to be what happens. You don't have that choice anymore.
Right. I understand since we're centrally located in the heart of downtown Brampton, we have staff members and assistants and clerks that speak a number of languages.
Yeah, absolutely.
I understand we have staff that speak Punjabi as well. Kate, why don't you give the viewers your contact information? And I want to say thank you very much for coming on the show, and let them know a little bit about your office hours as well.
Absolutely. So thank you so much, Paul. It's been a pleasure being here. So as Paul mentioned, we are right in the heart of downtown Brampton, right near the Four Corners. We're open Monday through Friday. And if you want to get a hold of me or part of our Wills and Estates team, you can reach us at 905-451-6610.
Again, thank you very much for watching Primetime TV. ਜਿੱਦਾਂ ਅਸੀਂ ਦੱਸਿਆ ਸੀਗਾ ਅਸੀਂ ਅਟੈਂਪਟ ਕਰਿਆ ਕਰਾਂਗੇ ਰੈਗੂਲਰਲੀ ਡਿਫਰੈਂਟ ਲੋਅਰਸ ਨੂੰ ਲੈ ਕੇ ਆਉਣ ਨੂੰ ਸੋ ਦੈਟ ਆਪਣੇ ਵਿਊਅਰਸ ਨੂੰ ਅਸੀਂ ਇਨਫੋਰਮ ਕਰ ਸਕਦੇ ਹਾਂ ਜਿਹੜੇ ਵੇਰੀਅਸ ਏਰੀਆ ਲਾਅ ਦੇ ਵਿੱਚ ਆ ਥੈਂਕ ਯੂ